Good evening, uh, everybody. It gives me great pleasure to introduce my very dear friend, Rotarian Suhail Ahmed. We have gone out on many trips on safaris and spent some fantastic time together. And I have very fond memories of our journeys. And he's the go-to person for my entire family whenever we have a legal or civil property related topic that we need to consult. Both Sanjay and Suhail are the go-to people, and personally Suhail has helped us to come out of some challenging situations that we had with properties, and also helped us to register one of the properties. So he's somebody that I would highly recommend that any of you need to go to. He's the go-to man as far as making sure that you have somebody on your side to ensure that the documents that you are having are in place, and they're in proper shape, and you have a friend on your side. So he's the founder partner of a law firm Trial Base Advocates based in Bangalore. He is the principal legal consultant of RERA Consultants LLP, a member of the Rotary Club Rajmal Vilas since 2008. And he's been practicing in the field of property laws, corporate laws, and other civil laws, having more than 20 years experience in the field of property laws. Former chairman and legal committee and member of the core committee of National Real Estate Development Council of Karnataka. He has contributed and spread awareness of the Real Estate Regulation and Development Act 2016 across the southern states of Karnataka, Telangana, Andhra Pradesh, Kerala, and Tamil Nadu, and he has conducted many workshops in Hyderabad, Bangalore, and Telangana, and so many other places he has done. So, ladies and gentlemen, I present to you Suhail Ahmed. Suhail, over to you.
Thank you so much, Shankar, for that introduction. I've also enjoyed our journeys together, and it's been a great time being in Rotary. Of course, I have not been active for the past couple of years, and I hope to come back and be an active member soon. Okay, so let's get to the. Can you see the screen?
Yeah.
Okay. So most of us have heard RERA, and we keep reading about RERA in the newspapers, the good and bad of it. So I'll be taking you through some of the basics of RERA. First of all, we need to understand why RERA. So let me. Okay. Before that, I'd like to tell you what topics I'm going to cover. The real estate sector and need for regulation and objects of RERA. I'll be taking you through some of the important definitions of RERA so that you understand what the law is all about. Duties and obligations of promoter we should know, because that will give us an idea as to what we can ask of a promoter. So I'll be dealing with, we call a developer as a promoter now under the Act. So wherever I'm referring to a promoter, it means a developer or a builder. Then I'll be taking you through some of the provisions under which home buyers are protected under this Act. Then we have the rights and duties of home buyers. As home buyers, what are our rights and what are our duties also. Then the flow of real estate transactions after coming of RERA, the adjudication and dispute resolution under RERA, offenses and penalties. I've tried to keep it as simple in terms of language. Of course, I can't avoid legal language to a great extent, but yes, I have tried to make it as simple as possible so that you can understand. If any of you have any doubts, you can stop me in between and ask, provided that we have time. I'll probably try and wrap up as early as possible so that I'm sure many of you may have some doubts or clarifications. I'll be able to answer. You can anytime stop me if that's okay with Bharat and Shankar. if that's okay, I'll be more than willing to answer any questions that any of you have. So real estate sector, as we know, it's one of the largest, it's actually the second largest employer after agriculture. And the contribution to the GDP is about 6.5 to 7% currently. And it's expected to grow to 13% by 2025. And as we all know, there were many irregularities, delays in completion. There's no accountability, large scale mismanagement of funds, and we have seen in the north, in the Delhi NCR region and Noida, there have been large scale difficulties of home buyers where promoters have not completed projects. If we are seeing that in Bangalore also now, of course, that is the reasons are many. Not all promoters are willingly default, but there are some of them who willingly default, who divert their funds and misappropriate the funds. There have been many cases of cheating and all that. So as we know, for the banking we have RBI, for stocks and exchange we have SEBI, for insurance sector we have IRDA, for food we have FSSAI. So to regulate the real estate industry and to make sure the mischief in the industry is corrected, we now have the Real Estate Regulation and Development Act. Part of it was enacted in 2016. That is to make sure that the regulatory authorities are put in place and everything else is put in place. The operative portions of the Act came into effect on 1/5/2017, and then thereafter we are now almost 3 years into the Act, and we are currently seeing the regulatory phase of the Act. So why the regulation? As we all know, the anybody and everybody is in the real estate business. The general progression of a person is somebody who's a cement supplier or a contractor, then becomes a promoter, then becomes a movie director, then becomes finally a politician. So that is the general progression in the industry. So we never knew whether that person is qualified, because this is the only industry where you don't, this and of course politics is the two industries where you don't need a qualification to be in the business or the profession of politics. So now with RERA coming in place, we can actually go visit the website and see what the promoter, who the promoter is. Well, of course, we don't know the qualification, but at least we know what they are and what they are promising. So time is the other thing, and since it's an immovable property, the initiation and completion of time is long and uncertain. So we never knew. There are projects which are still going on for the last 10 or 12 years and not completed. So people who have invested their money are stuck in such projects. It was very easy to litigate by paying small fees, and which used to give undue advantage to parties, that is mostly the promoters, who were able to defend any earlier, of course, before the coming of RERA, we had the Consumer Protection Act. It was very easy for them to delay the proceedings. There was no transparency, no accountability, no financial discipline. This is one of the biggest reasons why we needed this regulation, because there was absolutely no financial discipline. Promoters would start with one project, and then right behind that they would start a couple of more projects, take the money from one project, put it into the other. And if one project got stuck, it was a chain reaction. All the projects would be stuck, and all the allottees or all the home buyers in all the projects would be stuck. There were more disputes, which obviously used to. There is a burden on the judiciary. Now with the coming of RERA, we have a regulatory authority which deals only with the matters relating to real estate. We will, as we go further, we will see the applicability, in which cases we can go before RERA and which cases we cannot go before RERA currently. There was no standardization of agreement and transactions. As we all know, there were mostly one-sided agreement, which mostly favored the builder. We also, I don't know if you all know the famous DLF case, where DLF was penalized about 650 crores for getting into agreements which are one-sided. There was no authority to look into development and promotion of the industry. So with the RERA, and the name, as the nomenclature of the Act itself indicates, it is Real Estate Regulation and Development Act. So the Act aims at regulating the industry as well as the development of the industry. Currently, of course, As I said, it's still in the regulation phase. Maybe as we go further, the development aspect will also be taken up. So what are the objects of RERA? Um, uh, one is to ensure accountability towards allottees and protect their interest. This is one of the most vital things, because as long as allottees are protected, the money is protected, there is discipline in the industry. So what happens is, whatever the promises are made by a promoter, those will start getting delivered. We are now seeing a backlog of some of the ongoing projects which were launched prior to RERA. But those which have been launched after RERA, we will see a lot of accountability in such projects in terms of financial discipline and everything. Next is to infuse transparency, ensure fair play, and reduce frauds and delays. So by transparency, we, as we go further, we'll see what are the things that as a home buyer, you should know about. You should know about the project, and what is the duty of a promoter to disclose to a home buyer. Ensure fair play. So as we know earlier, there were many promoters who would construct buildings or come up with projects where they would not obtain the necessary sanctions like occupancy certificates, or construct more than what has been sanctioned. So what used to happen is that a promoter who's complying with all the laws would not be able to fetch the same returns as against a promoter who's right next door, who's violating and constructing more and selling at a lesser price. Thereby, there was no fair play in the market. So this ensures that all promoters who register their projects, or whose projects are liable to be registered under the Act, there is a fair play in the market, because all of them follow the same thing. Introduce professionalism and pan-India standardization. When you say professionalism, some of the regulatory authorities are already rating the promoters. So we will have very soon, maybe pan-India, we will have a rating of promoters. So you will have a single star, 2-star, 3-star. So those kind of rating mechanism will come in play. So which will force the promoters to be professional in business and adhere to all the requirements of the Act. Establish symmetry of information between the promoter and the allottee. So which means that what the allottee should get in terms of information, in terms of what are the documents that have to be finished. So far, it was only on demand the allottee would get. Of course, even before this, we had the Karnataka Apartment Ownership Act and the other acts which made it mandatory for the promoter to give those details, but there was no regulatory authority under those. So hence, nobody was following that act, and there was no implementation of those acts. With the coming of RERA, it has now become mandatory, and as a matter of right, an allottee can ask, or a home buyer can ask for information. Imposing responsibilities on both promoters and allottees in terms of what are the things that have to be done. And when it comes to home buyers, now the Act imposes a condition that whatever are the terms of the agreement in terms of making payments to the promoter, an allottee has to adhere to that also. So it makes not only the promoter responsible, but also a home buyer responsible. Establish a regulatory oversight mechanism and to enforce contracts. Next is to establish a fast-track dispute resolution mechanism, because now under RERA, the disputes are summary in nature. We don't have the prolonged method of civil trial before a civil court, or the proceedings before a consumer forum. It generally used to take long time. Now all disputes before RERA are mandatorily to be disposed of within 60 days. However, as we know, in India, we have the problem of numbers, but nevertheless, the authorities are disposing of all complaints, everything within a shortest period. The next is promote good governance in the sector, which in turn would create an investor confidence. So these are the objects with which the Act has been enacted. Next, I'll take you through some of the basic definitions so that you understand these while I'm talking further, or for your own knowledge. What is to be registered under the Act is a project. the project either consists of apartments or plotted development. The act covers both plotted development projects, apartment projects, you call them row house projects, or and also the villa projects. Any real estate project that meets the requirements of the applicability of the act is required to be registered. Why I'm taking you through the definition of apartment is, we earlier had there are two things. One is an apartment, one is a flat. So we have the Karnataka Apartment Ownership Act, and the other one is a KOFA, which covers flat. So Apartment Ownership Act would cover only the residential projects, and KOFA covers both. A flat is both a commercial and a residential premises. So when you see the definition of an apartment, it includes everything. Anything. It could be an office, it could be a showroom, it could be a shop, it could be a flat, it could be anything that is that comes within the definition of any unit in a real estate project is now called as an apartment, and it is covered within the act. So be it a showroom, wherever there is a sale of any of this, then the act would apply. So it includes both commercial as well as residential units. Next is the carpet area. So as we all know that generally before the coming of RERA, what used to be sold is the super built up area, and there is absolutely no definition of super built up area anywhere. So you don't know. So when delivered to you, you actually %, 85, 40%. So if you are being sold an apartment saying it has 1,400 square feet super built up area, what you may actually be getting is only 1,000 or 1,100 square feet. So you never knew what is the net usable area. Now the Real Estate Regulation Development Act makes it mandatory for a promoter to disclose what is the carpet area. Of course, this definition of carpet area is also not agreed by, not as per the engineering standards, but this definition has now been adopted even in the Income Tax Act for the Pradhan Mantri Awas Yojana and everything else. So generally, we can say that this is the definition now for carpet area. Carpet area means the net usable floor area of an apartment, excluding the area covered by external walls, and include the service shafts, exclusive balcony or veranda area, and the open terrace area. It includes the area covered by the internal partition walls. So this, if you see this sketch, so the balcony, the enclosed balcony, these balconies, the service area, these are all excluded from the definition of the carpet area. So including the external walls. So whatever is inside the internal surface, including the internal walls, is the carpet area. So now when a promoter is selling, he has to disclose the carpet area not only to the authority but also to the allottees. So if there is any reduction in the carpet area, you can always seek for refund of the money to the extent that the carpet area is diminished, or that is the lesser area that is delivered now. Next is the definition of common areas. Common areas has also been defined in other acts. Now, common area, it is necessary to understand common areas because what is to be transferred in a project under the section 17, which deals with transfer of title, is the carpet area is to be delivered or conveyed to the allottee, and the common areas are now required to be conveyed to the association of allottees. So earlier there was no requirement of conveyance of these common areas, but now with the coming of RERA, the common areas are required to be conveyed to the association of allottees, that is transferred to the association of allottees. However, currently this is possible only in Maharashtra because Maharashtra follows a cooperative system of managing apartments. We are still dealing the other acts, including the Karnataka Cooperative Society Act, Societies Act, the Karnataka Apartment Ownership Act. They need to be amended a bit, and also the stamp duty that is to be paid on a conveyance of the common areas is yet to be decided. However, this is what the act requires, and common areas as defined under the act, it includes the entire land for the real estate project, all the staircases, lift lobbies, the common basements, uh, the common storage areas, water tanks, all community and commercial facilities, all these are included within the definition of common areas. The only difference is that in the Karnataka Apartment Ownership Act, and all states have their own apartment ownership acts, there all car parking areas were included in the definition of common areas. Now, under the act, only under RERA, only open car parking areas are included in the definition of common areas, which means that the covered car parking areas which are allotted along with the apartment are not included within the definition of common areas. So the covered car parking areas get conveyed to the allottee along with the apartment. Only the open car parking areas become the property of the association of allottees, and they have absolute control over the open car parking areas, but not the covered car parking areas. Next is the definition of interest. Now, earlier we knew that in the agreement, when an agreement used to be made for sale of an apartment, a plot, or whatever, generally the interest payable in case of delay by a home buyer would be 18% or even more sometimes. And in return, when the delay on the part of the promoter, if there was a delay on the part of the promoter, they would stipulate a nominal sum of 2 rupees, 5 rupees per square foot, which would not be equivalent to the 18% that would be levied in case of a delay on the part of the home buyer. Now, with the coming of the act, promoter or the allottee is equivalent. So it means the rate of interest payable by the promoter or the allottee as the case may be. So in either cases, this will be the interest that will be payable. So in Karnataka, this is defined under the rules which are notified by each state. Under the act, each state is required to notify the rules because the land laws are different in each state. So each state has notified its own rules. So in Tamil Nadu, it is repo rate plus 2%. In Karnataka, it is SBI MCLR plus 2%, which works out to about 10 point in Karnataka currently. I think it is 10.25 plus 2%, about 10.75% is the interest payable in either cases. Next is the occupancy certificate. As we all know, earlier most of the promoters did not obtain the occupancy certificate in the apartment buildings or in any building that used to be constructed. Of course, this was not applicable to large apartment complexes, but medium and small would never obtain the occupancy certificate. Now it is, of course, the duties of promoter. One of the primary duties of the promoter is to obtain the occupancy certificate. The definition of occupancy certificate, it includes, it means an occupancy certificate or such other certificate by whatever name called, issued by the competent authority. The only additional, so occupancy certificate, of course, any promoter can get once the structure is completed. But now it makes it mandatory that it should have provision for civic infrastructure such as water, sanitation, and electricity. So merely obtaining an occupancy certificate would not mean that a building is completed now. It should have provision for civic infrastructure such as water, sanitation, and electricity. Only then it can be said that the occupancy certificate obtained is complete, or the development work is completed. So just to add to this, now the development work is defined as internal as well as external development work. A promoter who has promised certain things in a project while promoting the project, whatever the amenities and facilities that are promised in the project has to be completed. These definitions, these you will find in internal and external development works. Internal development works are all such works which are there in the plan that is sanctioned for the project. External development works are such works, it could be the landscaping work or providing a connecting road. Let's say that a promoter, the project is little away from the road and the promoter has promised that a road access will be given. That becomes part of the external development work. If a promoter has to provide electricity from drawing power from some other line, laying of that line becomes external development work, so that has to be completed. So now there is a mechanism to see whether a development work is completed, so that the terms of the agreement stipulate an end date, that is when the apartment is going to be handed over. It's not merely handing over of the apartment, but handing over of the project itself. So when we say completion, it's not just completion of the work in the apartment, but completion of work in the entire project. So that is what, as a home buyer, you can say that if a promoter is delivering an apartment without having completed the amenities that have been promised, then it does not amount to delivery of possession after completion. So a promoter now has to mandatorily complete everything and only then ask a home buyer to take delivery of an apartment or a plot or whatever it is. Next is the definition of a promoter. As I said earlier, now a builder or a developer is now called as a promoter under this act. So we always refer to a developer as a promoter under the act. It is a person who constructs or causes to be constructed any real estate project. So what do we understand by saying a person is the person who constructs? So by virtue of this, effectively, in cases of mostly in cases of joint developments, the landowners are also now brought in within the definition of a promoter, and they are also responsible to comply with the requirements of the act. So in case anybody has purchased a plot or an apartment from the owner's share, in case of a joint development with area sharing, such a home buyer can also go against the landowner who has sold his or her share and seek protection under the act. Next is any development authority or any public body. So by this we know Karnataka Housing Board is there. We have Bangalore Development Authority, who also construct apartments, develop residential layouts and sell to the general public. So now these are also brought within the ambit of the act. We know now that BDA has also registered some of the projects, and there are complaints already filed against BDA also in some of the layouts have delayed way beyond their time. So even public authorities are also now brought within the ambit of the definition, where they are developing, they are either constructing apartment projects or developing residential layout projects which they want to sell. So the whole thing is that um, a project where development is taking place and where any portion of the project is to be sold, subject to the requirements of the act of mandatory registrations. So where there is anything that is sold will be called as a real estate project. For such a project, anybody, it could be a public body, it could be a private promoter. If you see here, any person who acts himself as a builder, colonizer, contractor, developer, estate developer, or by whatever name claims to be acting as a holder, even a person claiming to be a holder of a power of attorney, is also called as a promoter. Whatever you call yourself as, if you are developing a project and if you are selling either the entire project or part of it, you are now called as a promoter, and such a promoter is responsible to comply with the requirements of the act. A real estate agent is also vital, because under this act there are two things, as I said earlier, two things that need to be registered. One is a real estate project, the second is the real estate agent. A real estate agent is also required to register under the act and is also required to comply with the provisions of the act. The definition of real estate agent includes any person who mediates between the buyer and the seller and is receives remuneration in any fee, in any manner, receives remuneration or fees or any other charges for his services. So whether as commission or otherwise. So any person who is acting as a medium between a promoter, this only applies, a real estate agent in this context only applies to such real estate agents who are promoting projects registered under RERA. So it will not apply to agents who are basically dealing with individual houses or sites which are second sale. These are basically the first sale, and where they are acting as a medium between a promoter who has registered the project. So all others are not covered under this act. They need not register. However, the moment they are promoting a registered, RERA registered real estate project, they have to register under the act. A real estate agent can be registered as either as an individual or as a company. Of course, the fees differs. For a individual agent, it is about 25,000 in Karnataka. For a company, I think it is about 2 lakhs. So this is the registration. The registration for a real estate agent is valid for 5 years, and subsequent to 5 years, they have to renew the registration. For every state in India, if they are promoting something in Karnataka and something in Maharashtra, they need to obtain different registration. This registration is valid only for each state. Next is the applicability of the act. So feet, such a project need not be registered, or the number of apartments proposed to be developed do not exceed 8. So any project where the land is more than 5,382 square feet or 500 square meters, such a project has to be registered. Or the number of apartments or plots, even plots, if it exceeds 8, that is, if there are 9 apartments, then the project has to be registered. And when the act came into force, that is as of 2017, if a project had already received the completion certificate or the occupancy certificate, then such a project need not be registered. Of course, the repair and redevelopment, we don't have that. This is mostly prevalent in Maharashtra and particularly in Mumbai, where old apartments are brought down and redeveloped. Even in such cases where there is only, if there is no new allotment, then the project need not be registered. If there is any new allotment, let's say that if a building is being pulled down now, and earlier the FAR achieved was 3 and 2.5, now they are achieving 3 FAR, and the additional apartments are being sold. Even in such cases, the projects would require to be registered. And the last is, of course, this is in a phase development. Every now, if in case a project, let's say that it's a large project where the project is being developed in multiple phases, each phase of the project can be registered as a separate real estate, standalone real estate project. So this is the applicability of the act. So what we have to remember is where the land is more than 500 square meters, such a project has to be registered. And where there are more than 8 units, the project has to be registered. So when it comes to registration of projects, a promoter, before advertising, marketing, booking, selling, offering for selling, or inviting persons to purchase, has to register the project. So we don't have the concept of a pre-launch now. Mostly earlier, before coming of RERA, all the promoters would do is enter into not even a joint development agreement. The moment they start talking to the owner, they would start promoting the project and start collecting money. And we know that a lot of promoters have collected money and vanished. So now with the coming of RERA, that cannot be done. The promoter has to enter, either if it's a joint development, has to enter into the joint development agreement, or if they are purchasing, they should complete the purchase obtain all the sanctions, including all the NOCs, all the permissions, all the licenses that are required to be obtained. Finally, only after obtaining all the permissions, sanctions, and the building plans, with all that details, they have to apply for registration of the project. Once they get the registration, only then can they advertise and market the project. There have been many instances where the authorities have penalized based on the advertising that they find in either on they also either online or in print media. Many promoters have been penalized, and these penalties are quite huge. It can go up to 10% of the cost of the project, which is quite huge. Many promoters have been penalized for advertising before registration of the project. So it is mandatory that a promoter registration not undertake any of these activities. Karnataka RERA has its own website. So all the details of the promoters and the project are visible for the public to go and view those details. So if you happen to come across a project where you can log into the website and view all the details of the project, the promoter, and the documents related to the project which have been uploaded. So one of the promoter for every quarter that is defined by the authority. Each authority has defined most of the okay. So every quarter, these details have to be uploaded, and of course, Karnataka has not yet enabled viewing of these quarterly updates. Some of the authorities have already done that. So once this is enabled, you can see the progress that is being reported by the promoter of the project, and you will, wherever you are, you will be able to see what is the progress in the project. Next is the advertisement or prospect. The registration number for the project has to be, there are guidelines issued in the manner in which these two have to be displayed. They have to be prominent. We see that many promoters are still not doing it, but the ones which are compliant, you will see always the RERA registration on the top right hand side of any advertisement, be it print or anything. Even if it is a radio ad, they have to mention the registration number. Many promoters have been penalized, and in Maharashtra, one of the promoters was in fact penalized about 50 lakh rupees for not displaying the RERA registration numbers. It can be as bad as that. So now it is mandatory that every RERA registered real estate project should display the registration number and the website address of the authority to enable any home buyer to go see the details. So the booking and issuance of allotment letter shall have these information, that is sanction plan copy along with specifications, stage-wise time schedule for completion of the project, including infrastructure. So when we say stage-wise time schedule, many of the promoters, of course, even to this date, even the large promoters are still not following this. They only say that upon completion, we will on every stage you are liable to make the payment, but they don't tell you when this stage will come. So what happens is it becomes very difficult for us to know when these when you are supposed to be ready with the money. So out of the blue, you'll get a demand letter saying within 30 days you have to pay this money. So sometimes it becomes difficult for you to arrange the funds to make those payments in such a short time. And we know the properties now are sold, anything, a decent place, anything than a half. When we get the stage wise time schedule, we know this particular month we can expect a demand to be raised, and so that we are prepared in advance to make those payments. So it is now mandatory that the stage wise time schedule for completion is given, not not even at the time of agreement, but at the time of the allotment itself. So we'll as we go further, I'll tell you how the flow of the transactions have to be now under RERA. So this is one of the mandates under the Act. Next is the obtaining of completion certificate and occupancy certificate. There are many promoters who have registered their projects and then violated the building bylaws. They are unable to now obtain the occupancy certificates. It becomes very difficult. The authorities initiating proceedings against such promoters where they have not obtained occupancy certificate and the allottees home buyers have complained to the authority. It can go to the extent of penalty up to 10% of the project cost and also imprisonment. So that is the power of this act, which has over non-compliant promoters. So one of the main functions of the promoter now is obtaining the occupancy certificate, maintenance of essential services on reasonable cost up to takeover of association. So this is also one of the important things, because the promoters do charge advance maintenance charges, and they arbitrarily start deducting from those maintenance charges even before they have completed the project or handed over to the association of allottees. But now under the Act, it is made mandatory that they should maintain the essential services on reasonable cost up to takeover by association. Next is the formation of association of allottees within 3 months of majority of allottees having booked their apartment or plot. So the formation of association, that is the apartment owners association as we commonly know it as, generally this was postponed to all the apartments being sold in the project. The mandatory minimum 12 months advance maintenance charges that were collected, they would spend all that. This was postponed till the end, and many promoters, even the prominent ones, never formed the Apartment Owners Association by executing the deed of declaration under the Karnataka Apartment Ownership Act. However, now it is made mandatory that within 3 months of majority allottees having booked, so even merely booking is enough for them to go ahead and form the association of allottees under the local laws. Now, under the local law, it is now under the Karnataka Apartment Ownership Act or the Cooperative Societies Act. The association should be formed so that the association or the allottees can take up any issue of there is also a requirement when the registration can be revoked. The first right of refusal to take over a project is to be given to the association of allottees. So it becomes important in such cases that the association is already formed and is there to be able to take over the project in case the promoter defaults. Next is execute sale deed within 3 months from the date of obtaining occupancy completion certificate or occupancy certificate. This is also now mandatory. It has been made mandatory that within 3 months they have to execute the sale deed. It may be difficult in case of large projects, but this is the requirement, and most of the promoters are not adhering, but they will so once an agreement has been entered into, once a apartment or a plot is allotted and an agreement is entered into, no charge can be created. And even if it is such a charge is created, it will, so no charge can be created on the, such an apartment or a plot. And if such a charge is created subsequent to the agreement having been entered into, it will not have any effect on the right and interest. So financial management of promoter, as we earlier discussed, I'm taking you through these things so that you know what, um, how RERA acts as a mechanism to control a promoter, and you should know this so that to understand what are your rights as a home buyer. So a promoter now cannot collect more than 10% of the total price of the apartment or a plot. Let's say if it is 1.5 crores, a maximum of 15 lakhs can be collected. Any amount more than 15 lakhs, if it has to be collected, they have to now mandatorily enter into an agreement and register that agreement. So earlier we would have unregistered agreements, but now if any advance is to be taken more than 10% of the total price, an agreement has to be executed and it has to be registered. This has been made mandatory now under RERA. So out of the money collected from allottees or from the home buyers, 30% of the money is free to be utilized by a promoter. The remaining 70% has to be deposited in a designated account, designated project account, which has to be in a scheduled bank to cover the cost of construction. So effectively, if a promoter collects 10 lakhs, 3 lakhs is free to be used by him in whatever manner, him or her, what in whatever manner. The remaining 7 lakhs has to be deposited into this account. That money has to be utilized for the project, and any withdrawals from that separate RERA designated account, they have to be supported by the certificates issued by an engineer, architect, and CA percentage of completion of the project. So when we say percentage of completion of project, if 10% of the project work is completed, however money collected is 50%, let's say out of the estimated cost of the project or the sale, out of the sale proceeds, the money that can be withdrawn from the separate account is only up to the extent of 2 crores and not above. And that has to be certified by an architect, engineer, and a CA in practice. That is for every withdrawal. If the withdrawal is if it is in proportion of, and this again be certified in the audit. Time do I have?
Bharat?
Okay. So coming to the provisions under which home buyers are protected, The first is section 12, which deals with the obligations of promoter regarding veracity of the advertisement or prospectus. So based on the advertisement, if a home buyer purchases any apartment or a plot in a project, and if there is a false statement made in such advertisement or prospectus, including the model apartment. So many a times it happens that the model apartment that is shown would have a certain type of material, and then when actually what is delivered, there will be something else. So if any loss or damage is sustained because of any false statement or anything that is shown in the model apartment which is actually not delivered, then a home buyer can go against the promoter and seek for making good of such a loss or damage. So in a model apartment, let's say some fittings are shown to be of a particular standard or particular model, and then or it could be a flooring tile, or it could be anything else that is shown but actually not delivered. Then a home buyer can go against the promoter and seek for damage, seek for making good such damages that are incurred because of such a misrepresentation. Next is the section 14, which is adherence to sanction plans. So once the project is sold, the promoter has to adhere to the sanction plans. If there are minor changes in the specifications of the apartment, of an individual apartment, even in such cases, the promoter has to take the consent of the allottee to make such changes. Let's say a particular tile was shown, or a particular marble or particular granite was shown that for the particular apartment. If a promoter has to go ahead and make any changes there, then the consent of the individual allottee has to be taken. If there is any major modification in the project, then it becomes mandatory for the promoter to take the consent of majority of the allottees in the project. This makes it mandatory that a promoter has to adhere to the sanction plans and specifications. And now the defect liability is extended up to 5 years. Earlier, the defect liability, of course, it used to be stipulated as 12 months, but nobody would actually adhere to that. Now it is made mandatory that from the date of possession, 5 years is the defect liability. If any defect is pointed out, the promoter is now to make good that defect or rectify the defect free of charge within 30 days from the date on which it is promoter is notified. And if there is any failure to rectify the defect, the allottee will get right to go against that promoter and file a complaint before the authority for compensation for loss that is incurred due to such a defect. These are the provisions, section 12, 14, 18, and 19, under which a complaint can be filed. I'll be discussing that further. That's why I'm discussing only these provisions. Next is the section 18, which deals with return of amount and compensation. So in this case, there are two things that can be done. If possession is not delivered as per the agreement, or due to discontinuance of business or revocation of registration, in any of these cases, if the home buyer wants to withdraw from the project, let's say that in the agreement, there is an end date given, that is the date on which the apartment would be delivered. If it extends beyond that date, and then the allottee does not, the home buyer does not want to remain in the project and wants to withdraw from the project, he can seek to withdraw from the project. And if he is allowed to withdraw from the project, the promoter will become liable to return the entire money along with interest. The interest, as we discussed further, it will be at 10.75% per annum. And if the home buyer does not intend to withdraw from the project, then he will become eligible to be awarded penalty by way of interest for every month of delay till handover of possession. So most complaints are now being filed under this section, where the home buyers either want to withdraw from the project or are asking for interest or penalty on the delayed possession. Next is the rights and duties of home buyers. This is dealt with under section 19. As a home buyer can file a complaint against the promoter, now a promoter can also file a complaint against the home buyer. This was never there because it was not permitted under the Consumer Protection Act or anything else. The only possibility was filing a civil suit for damages, but under RERA now, a promoter can also file a complaint against the home buyer if they do not adhere to the rights, the duty there, or if they don't perform their part of the duty under in case of a real estate project. So, as a right, what are the entitlements? Obtaining information regarding sanction plans, layout plans with specifications. This is mandatory now that a promoter has to give. As I discussed earlier, the stage-wise time schedule of completion of the project is required to be given to the allottee. Claim possession of the apartment as per the time period of completion committed by the promoter if a date is set in the agreement or any other communication saying that this will be the time, this will be the date on which the possession will be delivered. An allottee can claim possession on that date. If the possession is not given, then under section 18, you can file a complaint and seek for penalty. Claim for refund, as I said earlier, that if the apartment or the plot is not delivered, he can also claim within that time stipulated. He can also claim for a full refund. Next is just to take you through the definition of an allottee. Now, an allottee means a person who's the first purchaser and also the subsequent purchaser who purchases such an apartment or a plot. It does not mean just the first purchaser, because the provisions of section 14 extend up to 5 years. So if an allottee purchases it and within the first year he sells it to another person, then that person sells it to another person, all of them are covered under the definition of an allottee. The other important thing is under section 18 now, the liability of a promoter to ensure that the title of the property is good extends in perpetuity and there is no limitation for a claim. Let's say an apartment is sold and 10 years down the line it is found that it is either constructed on a property which does not have a title, or in most cases, as we have seen, many apartment buildings are constructed on valleys and lakes and lake beds and all that. So when the title to a property is lost, an allottee without any limitation, that is, it could be 10 years, 15 years, so effectively in perpetuity, of course, hoping that the promoter is still there and that's a company or is able to make good the loss. An allottee can go against such a promoter saying that the title to the land is lost and then claim for refund of the money. So this is an additional thing which I could not discuss earlier. This is also another protection that is given to a home buyer. So you have protection as against the defect liability as well as the title in respect of a real estate project. What are the obligations of a home buyer? A home buyer is now expected to make payments in the manner within the times specified in the agreement for sale. However, subject to the fact that the stage-wise time schedule is given, is liable to pay interest on delayed payments. If a home buyer does not make payments on time and delays the payments, a promoter can file a complaint against the home buyer under section 19 and seek for interest, just the way a home buyer can do. It is now mandatory that the home buyers participate in formation of association. This also becomes a difficult aspect for a promoter to put together that group to form the association. So now, if the allottees are not coming forward, a complaint can also be filed against the home buyers. It is now made mandatory that a home buyer takes possession of the apartment or a plot within 2 months of issue of the occupancy certificate. So what happens is, if in some cases the allottees don't come forward and take possession for years together, some of them may not be residing in India or they may be residing in other parts of the country. They don't come forward and take possession, which causes a burden of maintenance charges not being paid. So many other issues, the upkeep of the property. So all these things being an issue, it is made mandatory now that a home buyer takes possession within 2 months from the date of occupancy certificate, beyond which they become responsible to pay all outgoings in respect of the such a apartment or a plot. Some of the promoters also charge holding charges, which are in the name, for every month of delay in taking possession, they charge holding charges, which are necessary to make sure that the apartment is kept in a condition without it getting deteriorated if and when the allottee comes forward and takes possession. Participate towards registration of conveyance deed. This is nothing but the sale deed that is executed in the end. So they have to mandatorily, once the final demand is sent and notice is given by the promoter to come forward and take possession, they are now required to come forward and get the registration of the conveyance deed. So what is the flow of real estate transactions after RERA? If you are buying anything in a registered, RERA registered real estate project, the promoter can only demand up to 10% of the total money, as I discussed earlier. So that is called as the booking. And then the allotment of the apartment or plot happens. Once the allotment is done, then thereafter, to receive any money more than 10%, the promoter has to execute and register the sale agreement, and only then you are required to pay any further money. Last is the transfer of title, where the carpet area is only required to be transferred to you and the common areas to the association. However, in Karnataka, currently the carpet area, the common areas are, if you broadly say what is a common area, when we said the entire land, it is nothing but the undivided share in the land. Currently in Karnataka, both the carpet area as well as the undivided share is being conveyed to the allottee themselves or the home buyers themselves. But what the act requires is the common areas is to be conveyed to the association. This also becomes important because when a property has to be redeveloped, as we know, there are already some apartments which are very old, which require to be redeveloped. At that point of time, when you have to apply for a plan sanction for that property, the revenue records and the municipal records should stand in the name of the association to enable the association to go forward and ask for a plan sanction. So that is why this becomes important. And some of the promoters start misusing this the land, and parts of which are not developed, they try to redevelop that or they try to misuse that. So that is why it is now been made mandatory that the entire land be transferred to the association of allottees. Then coming to the adjudication and dispute resolution, the complaints in respect of either by a promoter, complaints can now be filed by home buyers against the promoter as well as the real estate agents. If a real estate, while it was something else, you can also file a complaint against a real estate agent. For you to file a complaint under section 31, it is to be filed by an adjudicating officer. An adjudicating officer is a judicial officer, which is he's a retired district judge who is appointed only for adjudging compensation under sections 12, 14, 18, and 19, which I just discussed. 12 is veracity of advertisement, 14 is adherence to specifications, 18 is return of money, return or payment of interest. So when you are filing a complaint, you have to make sure, because it's an online process, we are seeing that complaints are filed in every possible manner. Though it is an online process, it's not, still it falls within the legal ambit. You have to make sure that when you're filing complaints, you should know what are the provision under which you are filing, so that you know that when it comes up for hearing, you get what you are asking for. So under section 31, a complaint can be filed. This is an online mechanism. It's very easy. 1,000 rupees is the fees to be paid. You can sit at home and file this complaint against a promoter. Just that you have to take care while filing that you place the right facts before the adjudicating officer and you seek the appropriate reliefs. So when you're asking for compensation under any of these sections, you file a complaint under section 31. If there is any other relief that you are asking, you have to file it under section 35. This will go before the Real Estate Regulatory Authority, which consists of one chairman and two members currently. The chairman is a retired IAS officer. The two members, of course, they could be anybody else. As required under the Act. But in Karnataka, we have one member as who's a retired IAS officer, another member who is a retired IRS officer, an income tax officer. So anything else other than 12, 14, 18, and 19, you can file before the authority. Let's say that a promoter has not formed the association within the 3 months. If you want to file a complaint, you can file a complaint under Section 35. It will come up before the authority. A promoter has not furnished, has not made available all the amenities and facilities in the project, then you can file a complaint under Section 35 and seek for directions to the promoter to make available all those amenities and facilities. So anything else which amounts to violation of any of the other provisions of the Act, a complaint can be filed under Section 35. We are seeing many complaints being filed under Section 35 before the regulatory authority. I'm sure you must be reading in the newspapers also that many orders are being passed where the promoters are restrained from registering the sale deeds without obtaining occupancy certificates. So many such things are coming up before the authority and orders are being passed. So as against the orders passed either by an adjudicating officer or the regulatory authority, the appeal lies before the appellate tribunal. There is a separate appellate tribunal, which is called the Real Estate Appellate Tribunal. And any appeal that has to be filed challenging any order that is passed, has to be filed before the tribunal. And of course, the time stipulated for complaints under Section 31 is 60 days. Within 60 days, they have to be adjudicated. The same is before the appeal, in case of an appeal before the appellate tribunal. And if you have to challenge the appeal order passed by the appellate tribunal, then a second appeal has to be preferred before the High Court, before the jurisdictional High Court. Just the next thing is the offenses and penalties under the Act. These are very stringent, and we have seen huge penalties being levied. We have seen penalties of 50 lakhs, 60 lakhs, 70 lakhs being levied under the Act now. So in case of non-registration of a project, up to 10% of the project cost and imprisonment of 3 years for continuous default. This is what is the thing. And we have seen that the authorities have levied penalty. In case of an agent who is promoting a real estate project but has not registered, penalty of rupees 10,000 per day during the default tenure or 5% of the property cost that he has assisted in selling. Providing false information, it goes up to 5%. Non-compliance of any other provisions of the Act, up to 5% in case of a promoter, and similarly is for the agent. Non-compliance with the order of the authority. So here the promoter 5%, agent 5%. Here the allottee also becomes liable to pay the penalty in case he does not adhere to any of the orders that are passed by the authority. So this is where an action can be taken against the home buyer also. So it becomes important that as a home buyer, you make sure that you comply with whatever is stipulated under the agreement as part of your obligations. Non-compliance with the order of appellate tribunal, in case of a promoter, it is 10%, agent, it is 10% of the cost of the property, and allottee again 10% of the cost, and imprisonment up to 3 years or both. So these are the offenses and penalties. I think with that, I come to an end. If you have any questions, I can answer your questions now.